Welcome to the Probate Nation. My name is Richard Ruddy. You know, we talk about probate on our shows regularly, and that typically involves probate in the state where someone lived when they passed away. Recently, we did a show about the probate process in South Carolina that covers that very topic if you happen to live in South Carolina. However, if someone lived in a state other than South Carolina but owned property there, like real estate or a car, how are those assets probated and passed on to the beneficiaries of the deceased person? The answer is through a process called ancillary probate. In this show, we will learn the nuts and bolts involved in undertaking ancillary probate in South Carolina, from how to initiate, steps to be taken after qualification, and how to wrap it all up and give those South Carolina assets to the non-resident decedent's beneficiaries wherever they may live. We're delighted to have back as our guest tonight a South Carolina attorney who will share her expertise and guidance on this topic. So let me introduce her. Our guest is the founding attorney of the Charleston Estate Planning Law Firm, a boutique law firm in Charleston, South Carolina, that focuses solely on estate planning and probate administration. She enjoys helping individuals and families plan for disability, illness, and death with proper estate planning. And she also assists individuals with the administration of estates through the South Carolina Probate Court process. Please welcome Charleston, South Carolina attorney, Eleanor Washburn. Hi, Eleanor.
Hi, how are you?
Good, welcome back. So, ancillary probate. So let's get started. Tell me, what is ancillary probate?
Ancillary probate is a probate that's filed in a state where the decedent did not live but had property. So there is a primary probate filed in one state, and then the ancillary probate is filed in the other state. So in an ancillary probate that I would be handling, it would be property in South Carolina, where the main probate was filed somewhere else.
Okay, so who typically needs to undertake the ancillary probate in South Carolina?
It would be the personal representative in the home state, because the personal representative in the home state is not authorized to sign property, sign deeds or titles or something to convey property in this state. So they need to come to this state to get the authority from the court to do that.
Okay. Well, let's continue this discussion. I know we both have kind of commented about some of the typical assets that would be subject to an ancillary probate. So we mentioned real estate and we mentioned a car. What other assets have you seen that have to be probated through an ancillary probate down in South Carolina?
The only other one that I can think of would possibly be a bank account from a local bank, where the bank would be requiring somebody authorized in this state to deal with it. That's the only other one I can think of.
Okay, well that's good to know. We're going to come back to that towards the end of the show, talking a little bit about how to avoid those problems. Let's go ahead and turn our attention now to how do we actually initiate probate. So what court oversees the South Carolina probates again?
The county court. Every county court in South Carolina has a probate court. Every county has a probate court. Okay. And a probate court judge. So the cases are initiated in the county in which the property is located.
Okay, so so the jurisdiction is going to be where the property is located. That's going to be the court that takes control of that particular probate. What do we file in order to get that process started?
It's a very simple process, actually, in South Carolina, and it starts with getting a exemplified copy, a certified copy of the probate court file in that home state, where whatever the process is in that home state, which is similar, a petition, an approval, a copy of the will if there is one, a copy of the death certificate, a copy of the letters showing that this person has been appointed by this home state. All of those, that whole file is filed with the probate court in the county where the South Carolina property is, and a request that the South Carolina court admit that case for administration. And essentially what that means is the court would honor the appointment of this personal representative who had been approved in this other state.
So once we have once that, what can be done with, for instance, the real estate? Um, um, what can be done with that once the ancillary probate's been initiated and the personal representative is appointed? What can we do? What can I do with that real estate now?
Right. Once that case has been, admitted to probate here, the personal representative then has the authority to either sign a deed over to the beneficiaries, and it would be what we call in South Carolina a deed of distribution.
Mm-hmm.
So it would be a South Carolina deed filed in the county where that property is located, and the personal representative would be able to sign that deed. Sometimes they would prefer or need to sell the property before it is distributed to the beneficiaries, and they would have the authority to do that.
You know, I'm going to come to this. Let's talk about what are some of the duties of the ancillary administrator. What kind of duties do they have?
I think the primary duty they have to their home state. So South Carolina just wants to be sure that this person is authorized in their home state. Once that it is once that file is filed here, the court assumes that the personal representative is going to do whatever they're required to do in their home state. So that's a very short process. Normally, the personal representative just either transfers the property or sells the property, and then the only thing we have to file in South Carolina is a copy of that deed or a copy of that closing statement. The court here just wants to know that the property's been distributed in some way or another. And we often also provide that same proof and documentation to the home state if the personal representative requests that of us.
Now, does the ancillary administrator have to file any inventory or accounting?
No.
Okay.
So again, the court here assumes that whatever obligations they have to the heirs in their home state, that court is going to make sure that they comply. So we don't have any requirements about that.
How about, before we while we're talking about real estate, do you normally then suggest before they actually do anything with the real estate that they do a title search just to make sure there's not any title issues or liens against the property?
I do. It just depends on, the type of property it is. If it's a house that, was a house that had title insurance, but if it's a house that's probably been in the family for a really long time, maybe we would look into that. But essentially when you are distributing property to the heirs, you're just distributing the property subject to all the liens as well. When you sell the property, there's going to be a title search done. It is important, I think, I don't always recommend a full title search, but just to make sure that we have that there aren't any liens, like you said, that have to be dealt with.
Sure. Well, let's talk about wrapping up the ancillary probate. You mentioned it a little bit, but how do we actually close this particular probate?
Interestingly, there's no form like we would normally do for a full probate. So we just need to prove to the court that we have distributed the property that was in South Carolina. And once we do that, there's not even really a discharge of the personal representative because they are the personal representative in their home state. So our probate courts here just want to make sure that that property has been distributed, and then they'll just close the file.
Okay, so there's no petition filed. Nobody gets notice of the filing of any kind or that.
Again, they're just relying on that home state to, they're relying on that personal representative's home state to make sure that they do everything according to their laws.
Sure. And is there a typical time from beginning to end for a normal ancillary probate?
If all we are doing is deeding the property, having the personal representative sign a deed of distribution to the heirs, that can be done within a couple of weeks. So, but if they want to sell the property or need to sell the property because of a mortgage or some other liens, then that might take longer, obviously, because we've got to, put it on the market, and then there's closing dates. So that could be, 6 months, a year. It just depends on the market and
Sure.
whatever area that property is in. So I'd say, it can be a few weeks to a year.
Okay. Well, let's talk a little bit about, obviously ancillary probate is involving assets that someone didn't address in their documents in their home state, okay? And they didn't plan for that. So let's talk a little bit about how we could avoid ancillary probate. So what's the typical cost, to begin with, what is the typical cost involved to initiate and complete a typical ancillary probate?
I think it would probably between $2,000 and $4,000 would probably be the range for attorney's fees to do that. Of course, that's going to vary by area, but I would think it would be about that.
So in order to avoid that ancillary probate and the cost that you mentioned, if someone owns South Carolina real estate and they live in another state, what could they have done to avoid ancillary probate of that real estate?
If that person had, instead of doing just a will, had done a trust, a living trust, where they would title their property in their living trust, ancillary probate is not going to be required because the successor trustee that's named in the trust would have a legal authority to sell the property without any court involvement. So whenever I have clients who have property, not just in South Carolina, but in other states, other vacation property, just second homes, I always recommend a trust because it can save a lot of money in the long run because we don't have to probate property in 2 different states. So the trust code just has that built-in power for your successor trustee to go ahead and sell the property.
That's awesome. But so sometimes a lot of people, still to this day, don't use a trust. They use a will, okay? So, or they have no will, as we've talked about in the earlier South Carolina program. Does South Carolina have something that's called a transfer on death deed? That would otherwise, the transfer on death means they could put a beneficiary in their deed in order to transfer it on death. And not every state has a TOD statute that allows for a TOD piece of real estate. Does South Carolina have such a statute?
No, we do not have that. And so you are not, you can't do a transfer on death deed. We have something somewhat similar, which is a life estate deed. So you could convey your property while you're living to somebody or some other people, but retain a life estate. And that would mean that when you passed away, the remainder owners, the people you had conveyed the property to, would then become the owners. And we call that a life estate deed. It's not ideal unless you have a good relationship with those beneficiaries. For example, if you deeded your property to your children and retained a life estate and you wanted to sell the property, you would have to get their agreement to do that. If you needed to finance the property, it might be difficult. So it's not always ideal unless you have maybe, a one child or somebody that is going to support you in whatever you want to do with that property down the road. So that is sort of the shortcut way of doing it here since we don't have TOD.
So if we do have a revocable trust and I wanted to get my South Carolina property deeded into my revocable trust from Virginia, what would I expect to pay to have that deed prepared and recorded?
When I would say just the quick answer to that would probably be $250 to $500. It just depends on the attorney and the state. So if I'm doing a trust for a client here, they have property in Illinois or Virginia or whatever, I would ask an attorney that I know in that state how much they would charge to do it. And,
sure.
So there's a range between $200 to $600, I would say, to have an out-of-state attorney do the deed, draft the deed. Since I don't practice in that other state, you would have to get an attorney in that state to do the deed, but it's far less expensive than an ancillary probate.
I think that's the point I was getting
Yeah.
at. The cost of having that deed prepared, whether
Mhm.
it's South Carolina real estate or Texas or, Iowa, it's just going to be significantly less expensive than having to go through the cost and the time of ancillary probate. Well, let's
Mhm.
talk a little bit. A lot of people nowadays are working remotely, and so a lot of people now are going to the sunny shores of South Carolina or some of the lakes around South Carolina and taking up residence and working from those locations. And so they bring with them, a whole host of estate planning documents that people like myself would have prepared. So when people move to South Carolina, let's just say they have just a will, okay? It's a will alone. What are the things you look at to determine whether or not that will is going to be probatable in South Carolina?
So when somebody moves to South Carolina and they come to me with their out-of-state will and want me to tell them whether they need a new will or not, one of the things that I'll look at is whether or not that will gives the personal representative certain powers that they need to have in South Carolina to administer the estate without a lot of court involvement. So that's one of the things I look for, the powers of the personal representative. Sometimes that will might be signed differently than what's required in South Carolina. But in South Carolina, as long as that will was validly executed in another state, it's validly, the state here will admit it to probate. It's also just a good time to look at your will to see if there's any changes that you want to make. But sometimes a will from out of state is okay, but it should be reviewed by an attorney.
Okay. So a lot of people, though, use revocable trust. So we do a lot of revocable trust in our practice. So and my clients move to South Carolina, they have a Virginia revocable trust. Okay. So hopefully I've done a good job to get them to put all the assets in their trust. Okay. So we're not worried about that. But, they're now in South Carolina. Okay. So, what would you be looking for in that revocable trust when it shows up on your desk when they come in to see you? What can you do with that? What would you suggest people need to take a look at or maybe change?
The most important thing I look at in a revocable trust that was drafted in another state is what state law would apply with respect to the administration of that trust, because that's what we predict will happen. That trust is going to be administered in this state, and we want to make sure that the state laws in this state are going to control. So that's something that I might want to change in a trust if it doesn't already say that.
I think it's a great answer, and I think that's important. We tell clients all the time when they move to Virginia that I'm not a South Carolina attorney, I'm a Virginia lawyer, so we can go ahead and maybe do an amendment to your trust to make it clear that now Virginia law governs. So in your case, we would make South Carolina govern so that way you can give them appropriate advice and have the advantage of all the appropriate statutes in South Carolina that give them all the powers they need. The two other documents that we see frequently as people go to other states that we are particularly concerned about, and let's talk about one at a time, is the financial power of attorney. So people haven't put all their assets in their trust, or they don't have a trust and just have a will. They're relying on a financial power of attorney to take care of those assets. I show up in South Carolina with my Virginia power of attorney, and I take it to a local bank. Are their heads going to spin, or are they going to accept that power of attorney?
I think that's kind of two questions. I think that what a bank is going to accept, we never know. But they probably
so true. It's so true.
They're probably going to prefer that it be a South Carolina power of attorney. If it is a South Carolina financial institution, we are going to want to look to see whether or not that power of attorney has all the requirements of recording. Certain types of powers of attorney in South Carolina have to be recorded, and they can't be recorded unless certain signing requirements have been met. For example, it has to have two witnesses and a probate. So those are things that almost all the time have to be redone when you move to a new state. And honestly, a new power of attorney is better than an old power of attorney. So the newer the better. I don't think it ever hurts to execute a new one.
I couldn't agree with you more, and we certainly always recommend clients get those updated. Now, the last one probably, which could be frankly the most important, has to do with health. Okay, being able to access medical records, HIPAA requirements being met, and every state seems to have their own set of rules as far as what they'll accept. And certainly, you've got hospitals that get concerned about looking at out-of-state healthcare documents. When someone shows up at your office, what's your thought about an out-of-state medical directive? Should that be updated or not?
I always recommend that they be updated. South Carolina has its own form. A lot of states do. And that form, that South Carolina state form, is what the medical providers are used to looking at. It may not be ideal, but it's the form that we have here. And so I always recommend that we do a South Carolina healthcare power of attorney, which is also a living will. We have a living will component to our South Carolina healthcare power of attorney.
I think that's excellent advice, and certainly we always tell clients to expect that, and they should do that because that's very, very important. Well, we're nearing toward the end of our show here, so I wanted to get your closing comments. We've talked a lot about ancillary probate, and in a prior show we talked about this South Carolina probate in general. But give me your final thoughts and words about what can be done and things you think people ought to keep in mind as they face a possible ancillary probate down the road.
I think the most important thing to avoid ancillary probate, it's just an extra step that you don't have to have if you just did a living trust along with your estate planning. And it could just be a very simple trust that just holds your real estate. And so that trust would say what you want to happen to that real estate when you pass away. And so that's the best and easiest thing to do to avoid ancillary probate and all the expense of it entirely.
I think that's excellent advice. Excellent advice. We know Eleanor, on behalf of the Probate Nation, I want to thank Eleanor for taking the time to visit the Probate Nation. All of us have learned a great deal about the work that will need to be done in a South Carolina ancillary probate. And I want to thank you, Eleanor, for highlighting the importance of updating your estate documents should you decide to relocate to sunny South Carolina, as many folks are doing these days. So thank you again for this valuable information and for this great public service.
Thank you for having me.
You're welcome. Folks, without a doubt, probate can be complicated and time-consuming. And this is even truer if you need to probate assets in another state, such as South Carolina, through a process called ancillary probate. Many South Carolina beach homes are owned by non-residents of South Carolina. Our show tonight introduced you to the process that will need to be undertaken should the estate of a non-resident need to probate that beach house. While the process is consumer-friendly, I would be remiss if I did not emphasize the importance of consulting with a local South Carolina attorney about any such probate before you need to initiate it. The guidance of an experienced professional will help you avoid unnecessary work and shorten the time you ride the ancillary probate train ride in South Carolina. This concludes our show this evening. We hope you found it informative. Just a reminder that replays of this show can be viewed on the Probate Nation website and on its YouTube channel. And if you want to receive monthly tips on guardianship, conservatorship, and probate, please sign up for the free Probate Nation newsletter and join the Probate Nation. Until next time, I am Richard Ruddy, and this is the Probate Nation.